Okay, I'm Norman DeCosta, President of the Toronto branch of the World Federalist Movement Canada, welcoming you all today at today's presentation on legal alternatives to war. Toronto, where we are in right now, is in the dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee, the original indigenous peoples of this land, that bound them to share this territory and protect the land. The dish represents the land, and the spoon signifies the need to share resources equitably without conflict or overuse. There are no knives on the table, signifying that the peoples of the treaty must keep the peace. The treaty started around the 12th or 13th century and still remains a significant and respected principle among indigenous nations on this land. The dish with one spoon treaty is a shining example of how legal means can be used to avoid conflict and wars, and should inspire us all. Around the world today, conflicts of different intensities are ongoing, from simmering Chinese-Taiwan tensions in the Far East, to Myanmar in South Asia, to Sudan in Africa, to Ukraine in Europe, and in much of the Middle East. Today's presentation and follow-up discussion is on legal alternatives to war, envisioning a just and peaceful future for the Middle East. While we could have any of the conflicts I just mentioned for context, we have chosen the Middle East because it is perhaps the most complex and most covered by the news globally. As we go through the presentation and follow-up discussions, please remember that the topic we are covering is not, and I repeat, not the war itself or the wars themselves, but the legal alternatives available to the participants in the conflicts. For this reason, any questions outside the scope of this presentation, i.e. Legal alternatives to war, will not be taken up. Here to present legal alternatives to war, envisioning a just and peaceful future for the Middle East, I welcome Rebecca Shute. Rebecca earned a Juris Doctorate with honors from Emory University School of Law, where she received several academic distinctions, including the David J. Penniman Fellowship in International Law and Conway Ingram Scholarship of Public Interest Leadership. She earned a Master of Science in Democracy and Democratization from University College London School of Public Policy, and a Bachelor of Arts magna cum laude in Political Science from Kenyon College. She pages are stuck together. Holds certificates in conflict analysis from the United States Institute of Peace and in public international law from the Hague Academy of International Law. So those were Rebecca's academic qualifications. In nearly a decade with the National Democratic Institute, NDI, Rebecca held numerous positions in headquarters and in the field, supporting and leading democracy and governance programs in Central and Eastern Europe and Southern and East Africa. She subsequently moved to a leadership role, steering NDI's governance projects globally and directing programming for the bipartisan House Democracy Partnership of the U.S. House of Representatives. Rebecca created a global parliamentary campaign for democratic renewal and human rights as senior advisor to Parliamentarians for Global Action, PGA, an international network of legislators committed to collaboration to promoting democracy, human rights, and the rule of law. Prior to that, Rebecca directed PGA's International Law and Human Rights Program and ran PGA's office in The Hague. Most recently, she helmed global programming to promote gender equality and criminal justice reform for the American Bar Association Rule of Law Initiative. Rebecca's publications include the first Global Parliamentary Report, Political Parties in Democratic Transitions, and Navigating Between Skiba and Charitis, if I pronounce that right, I hope. How the International Criminal Court turned restraint into power play, which was honored with the Emory International Law Review's Founders Award for Excellence in Legal Research and Writing. It's my pleasure to turn the virtual floor over to Rebecca. Rebecca, please.
Thank you so much, Norbert, and thank you to all of your wonderful colleagues at WFM Canada for allowing me this space. As was mentioned at the outset before some folks joined, I am coming to you from Yerevan, Armenia, but I am normally based in Washington, D.C., where today I am Executive Director of Citizens for Global Solutions, which is the US-based member organization of the World Federalist Movement. We are so honored to collaborate with WFM Canada as well as WFM IGP, our global movement, very frequently, including publishing Mondial. I loved that you started your introduction of this topic with a great law of peace of the Confederacy that bridged New York. I'm originally a New Yorker and Canada. Alan Ware, as most mentioned, is on the line, and this seminal piece of legislation was hundreds of years after the fact, shortlisted for an award just a couple of weeks ago by the World Future Council for its Future Policy Award. And so we see how the arc of justice continues to bend, and that this is an evolutionary process. Um, I'll start off my remarks by talking a little bit about, I think, what I was brought here to discuss, which is a particular program, Legal Alternatives to War. I'll also situate this program within our contemporary moment to the best of my ability to do so, with two case studies. And I want to really stress at the outset here that I am not an expert on the Middle East, and also let's just acknowledge that that Middle East terminology is in and of itself loaded in perhaps a colonialist construct of where you define middle, where you define east. But especially given today's events, I thought it might be worth talking about what legal pathways to justice could look like. Um, but moreover, I'd really be interested in getting to know all of you and seeing how we could collaborate. The reason that I'm in Armenia right now is I'm coming directly from Den Haag, The Hague, the Netherlands, from the Assembly of States Parties to the International Criminal Court. This is the annual meeting of the guiding executive body of states to the ICC. Now I'm here in Armenia, mostly because it didn't make sense to go back to North America in between, for an upcoming conference on genocide in just a few days that's going to be held by the Prime Minister's Office of the Ministry of Foreign Affairs. And this looms large in this part of Armenia, as we can also discuss, which maybe by somebody else's definition might fall within the gamut of Middle East, is currently experiencing two cases before the International Court of Justice under the Convention on the Elimination of Racial Discrimination. And uh, there is substantial evidentiary basis to believe that there might be more claims under different treaties, say the Genocide Convention, in this part of the world. Well, getting myself a little bit. Legal alternatives to war is to many of you aware, remember, and probably criminal came into being in 1998, thanks in large part to the mobilization of civil society. 25 approximately civil society organizations got together in the 90s and with the great case at the helm. And many of you, again, I see some of you who would have been in those rooms and willed a court into being that then took effect in 2002. The International Court of Justice does not need to be willed into being. It has been a fixture of the United Nations system since the Charter in 1945 and resolving its first case in 1947, the Harper Channel case. And so the question might be begged, why is it necessary to have a coalition around the ICJ? And what does this coalition do? The Legal Alternatives to War remembers that the role of the International Court of Justice was to be the primary mechanism for the pacific resolution of disputes among states. It was to be the alternative to war. And yet, here we are, more almost 80 years later. Um, and only 74 states have accepted compulsory jurisdiction of the International Court of Justice. I'll talk a little bit about the jurisdiction of the ICJ versus the ICC. But both of these courts are busier than they've ever been. For just a kind of an overview, or just at a glance, the ICJ is considered approximately 125 cases in almost 80 years. It's currently seized of approximately 24. When you kind of look at that ratio, you get a sense of exactly how busy it is. Moreover, the diversity of the cases and the way that they're reaching the court, and who is availing themselves of the court, is also growing and changing and expanding, and I think improving. We can get back to that as well. And so whereas the Coalition for the International Criminal Court, founded in the 90s to take state action and take what had been an idea since Nuremberg to fruition of realizing a court that would be the hope for all humanity, in the words of the former UN Secretary General Kofi Annan, with the case of the ICJ, we are carrying on the labor of decades of forefathers and foremothers who have looked towards the Pacific resolution of disputes. And this story, and I won't spend too long in history. I have a colleague who's way better on that than I, but I will just give a little bit, I think, of a grounding narrative. This history doesn't start even after 45. It really starts 125 years ago. We're celebrating the anniversary of the 125th anniversary of the First Hague Peace Conference. And there at the First Hague Peace Conference, it was not held at the Peace Palace. That was the second after it was constructed. But just down the road from where Alan and I were a couple of days ago, you had the origins of a law of war, primarily around the humanitarian law, otherwise known as law of war, and the beginning of modern arbitration. So the signing of the Hague Convention during the First Hague Peace Conference enabled a mechanism for dispute resolution. Before that, it was not only the norm, but very acceptable, of course, for states to settle their conflict, their disputes through conflict, through going to arms. And the establishment of the Criminal Court of International Justice, which came after World War I, in the light of the Second Peace Conference, for which the first had paved the way, was the, I think, first attempt, or building on those attempts of 1899, to build the bricks and construct the architecture of a global justice system of accountability, and accepting that there are viable norms, good norms, in international law that withstand the purview of any state policy and withstand the diplomatic intent of any one administration. And so going up to this, we finally have in 1945, of course, the establishment of the International Court of Justice as the World Court. And the ICJ differs from its primogenitor, the PCA, in that its judges are permanently elected, and it handles contentious cases as well as providing advisory opinions. So when I say it handles advisory opinions and contentious cases, this is where our campaign comes in. There are 4 ways, which I'm sorry if I'm getting overly in the weeds. If anyone gets bored, just give me a little hand, but we'll get to the case study soon, which I'm sure everybody will be invested in. There are 4 ways in which cases reach. One is a request for an advisory opinion. Concurrent with this Assembly's case parties to the ICC, and I'll come back to the ICC in a minute, over this past week and continuing into this next week, there is going on in The Hague something completely unprecedented. A request for an advisory opinion that was unanimously referred to the International Court of Justice on the responsibility of states, the obligations, excuse me, of states with regards to climate change. And there, it was a group of youth, young people, primarily from the Pacific Islands, who agitated their governments to request an advisory opinion referral. The ICJ only has jurisdiction over disputes between states. And so this obviously took meticulous effort and an incredible amount of acumen politically and stitching together of all of these different judicial processes to finally get here. I say here, I'm actually in Armenia now, but there to The Hague over the course of actually not too long. The advisory opinion process is incredibly helpful. And when I say that it was a unanimous referral, I'll also mention that has been the most number of states and intergovernmental organizations that are allowed to make intervening remarks that have ever appeared before that institution, approximately 100. And moreover, what's reverberating from The Hague, I think, has already started to change policy within many domestic jurisdictions and also many blocs, including regional bodies. The ICJ also hears cases based on treaties, and we're going to talk a little bit about those. Compromissory clauses within treaties are the letter that tells you that this is the mechanism to resolve your dispute if you and another state are not of the same mind. And that can be anything from a territorial dispute to a serious case of trade law, to what we're going to be discussing around atrocity crimes and violations of international treaties there too. States can also accept, I always have trouble with this, accept exceptional jurisdiction. So they can just decide between themselves that in this instance, we're going to take this way out, and instead of resolving things on the battlefield, or instead of resolving things in a smoky back room where we don't know what the outcome might be and we don't know what to tell maybe our constituents. I'm trying to give you some of the reasons folks might do this. We give it to a neutral third party who is objective, who can give us an opinion. And then the last way, the fourth that disputes reach the court, which legal alternatives to war, law not war, the campaign seeks to further, is this compulsory acceptance of jurisdiction. So 74 states of the 193 UN member states have accepted compulsory jurisdiction, which means between them and any other state that also has compulsory jurisdiction, it is de facto the ICJ that will resolve their disputes. And we're not going through any of those other pathways that I previously mentioned. So the ICJ can play an incredibly powerful role in the specific resolution of disputes. And one of the reasons that I'm here in Armenia is that Armenia has not accepted compulsory jurisdiction, but stands ready to do so. And we actually had a public statement by a member of the Prime Minister's office this week that they see no reason not to do so. It shows very good faith by a state with regards to the project of international justice, and particularly states who are either at risk or in perilous situations, as Armenia currently is. It is an opportune time to avail of the court's jurisdiction. I can contrast for a moment. Or Norbert and John, as MCs, do you want me to pause at any point for clarifying questions before I move on to different segments of my discussion? I want this to be as free-flowing as possible and helpful as possible.
No, I think you can go ahead, Rebecca.
Okay, great. So we moved from the ICJ to the ICC, the International Criminal Court, which was established by treaty and entered into force on July 1st, 2002. And there are 124 states parties currently to the Rome Statute. Armenia, not too coincidentally that I'm here right now, but is the latest state party. And as of January 1st, 2025, Ukraine will be 125th state party. As opposed to the ICJ, which has jurisdiction over disputes between states, the ICC, and I do apologize if I'm repeating what many people in the room, the proverbial room, already know. But I think as we compare these pathways to justice and look at how they might be complementary, sometimes it bears revisiting the jurisdictional grounds. So the ICC only has, I shouldn't say only, has jurisdiction over over individual persons. And individual persons, if you come from the United States, sometimes we call a corporation a person with, or we say it has legal personhood under the law. No, we're talking about natural persons under the law when we talk about the ICC. And it has jurisdiction over 4 different crimes: genocide, crimes against humanity, war crimes, and the crime of aggression with an asterisk. If we want to get to the asterisk, we can get to the asterisk. But basically, there were amendments that were put in place after the foundational treaty took hold that allowed states to opt out of those amendments. And some of us, I'll include myself in that category, are trying to close those loopholes. And so currently, there have been 32 cases brought before the court, 59 arrest warrants, 3 preliminary examinations. And yes, I am looking at my notes because I don't have this all at the top of my head. And at large are 30 suspects. And the estimated budget for the court annually, to give you a sense of what it costs to support justice as opposed to what it costs to support war, is a bit under 200 million euro. I can't compare that off the top of my head to what Boeing fighter jets cost, but I know that it is a favorable comparison, especially in the course of history. So I think we're going to take this conversation as well into looking at how these 2 courts and tribunals, which, by the way, of course, are only a small part of the panoply of international judicial architecture that we have to avail ourselves of, could service justice when it comes to aggression or crimes against humanity or war crimes or genocide in the Middle East. I guess I'll just note before starting that part of my intervention that when I say that they're part of a panoply or part of a greater narrative or tapestry, there is very much the possibility that an independent tribunal could be in any situation initiated that's not necessarily competing with, but can be complementary to these judicial institutions that I've mostly focused on. In other parts of the world, there are regional institutions, human rights institutions, as well as in some cases, interstate institutions, such as in Europe, where you have both the ECJ, the European Court of Justice, and the European Court of Human Rights. The Inter-American court system has been hailed as path-breaking, with connecting atrocities to environmental justice, to indigenous justice. But if we are speaking about the Middle East, we don't necessarily have those avenues. But we do have some for the ICJ and the ICC currently. So I am going to start, I think, with the situation that just today took a turn and I didn't expect to speak about. So wish me luck. But in Syria, in the Syrian Arab Republic, where, as we all know, there have been intensely documented crimes against humanity being committed by the regime of Bashir al-Assad against his own people, with complicity of other states, for years, and where the veto power has curtailed justice. The veto has been used approximately 200 times, I believe, since 1946, when the USSR sent its first draft resolution on the veto. And the USSR and then the Russian Federation were the most perennial users of the veto over time. I'm sorry, 300 times, with other states, particularly France and the United Kingdom within the P5, showing more restraint. Now, since the aggression has began in Syria, um, China and the Russian Federation used the veto approximately 17 times as of last year, and I think that number is now more like 24. Of course, when we're also going to talk about the situation in Gaza, otherwise known as the Palestine situation in ICC parlance, which is the language that I'll be using when I talk about that. And there you see the United States using the veto from which it refrained from quite some time as well. The ways in which cases can reach the International Criminal Court, as opposed to the ICJ, which I talked about a moment ago. A state can refer. And here I'd like to maybe at the outset get out ahead of a perennial misconception about the International Criminal Court. And full disclosure, I did work at the International Criminal Court as a visiting professional in the Office of the Presidency, and I'm the co-convener of the Washington Working Group for the ICC. So take that with a grain of salt, but full disclosure. The ways in which a case can come before the ICC, and by the way, actually, there are several stages before a situation becomes a case, including preliminary examination, which those of us from common law jurisdictions are less familiar with, and those of us from civil law jurisdictions probably very well familiar with, where you have a pretrial chamber assessing jurisdictional issues, et cetera, et cetera. So a state referral can come by the state itself or by another state party. And when I said I wanted to address a misconception, it is the misconception that the ICC has unfairly or disproportionately targeted the African continent. It is very true that most of the cases, the majority of the cases heretofore before the ICC have been on the African continent. It is also true that the majority of those were self-referrals. So when a state says it is unwilling or unable to investigate and prosecute the crimes under the court's jurisdiction, the four that I just laid out, then it can refer to the court. And we've seen this numerous times, including multiple times by the same state, like the Central African Republic, or now the Democratic Republic of the Congo has a second referral. And so we see that. We also, you can refer if you're another state that has a ground for jurisdiction based on territoriality. So part of the crime in question, the alleged crime in question, was committed on your territory or by a person of your citizenship, person nationality. And so there, for example, looking at the Myanmar, Bangladesh situation, Myanmar is not a state party to the Rome Statute of the ICC, but, and I was part of the pretrial chamber that wrote this opinion, very limited jurisdiction, only over the crime of forced deportation was found based on the continuous nature of that crime and that crime ending on the territory of Bangladesh that is a party to the Rome Statute. Another way that crimes can reach the court is by proprio motu of the prosecutor's own initiative. But that has to happen if a state has accepted jurisdiction of the court, and it cannot happen extraterritoriality. And the last way is by UN Security Council. And so we've had that in the situation in Libya, in the situation in Sudan with regards to Darfur. And we had the opportunity numerous times in the Syrian Arab Republic for a referral to be made. It was the only way that a referral could be made unless you considered some of these, and I believe the Office of the Prosecutor, along with numerous civil society organizations who stand by and who are necessary in assisting in these processes, is looking at these options unless you consider this continuous crime angle that I just outlined with regards to Myanmar. But if you consider the continuous crime angle, it's only going to stop once you get to, or excuse me, I guess jurisdiction will only start once you get to a state party. So the mass killing of civilians by the Syrian Arab Republic government within its territory would be beyond the realm of that court, unless there were these other means. And that's where the veto power has come in the case of Syria. Now that we have, as of today, it looks like a new day in Syria, I'm reminded of the circumstances with regards to Ukraine. And the jurisdiction of the ICC is by and large prospective. There's no retroactivity for a state to be liable before it has accepted jurisdiction of the court, unless it specifically says that it wants the court to investigate crimes. It has to be after the date of coming into effect of the Rome Statute, so it has to be after 2002. But if a state were to say, as Ukraine did, that we would actually, in the Crimea situation, there are two situations currently before the court, including the obvious ongoing. But there was the Crimea situation that was first referred, and that was Ukraine made a declaration of retroactivity in its request to the court. If Syria is under a different regime, a different administration, it could potentially do the same, and it could potentially look for some accountability for the heinous crimes that have happened to date. The other thing that Syrian Arab Republic, of course, could do would be to accept jurisdiction of the ICC. That would be forward-looking. And both of these things would be an immense show of good faith, but one probably more than the other, a pathway to some measure of accountability for victims and survivors in the heinous situation there. Just want to see if I missed anything I want to mention on Syria. Not with regards to the ICC. So there's also a case before the ICJ with regards to Syria that comes under treaty law. Syria, like many countries, I think in the 170 realm, is a signatory, has ratified the Convention Against Torture. This is one of the few international human rights treaties that the United States, by the way, also has ratified, although we had reservations. That's a conversation, I think, for another day. But because of the massive and well-documented violations by the al-Assad regime against his people, Canada and the Netherlands brought suit within the ICJ, the International Court of Justice, on the application of the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, shortly known as Canada and the Netherlands v. Syria. And so that case is also currently with the International Court of Justice. And the ICJ can look at any manifest violations of CAT. And here, again, it is difficult when you have two courts, one of whom the ICC does in situations that are designated as situation countries, have the ability to collect evidence along with civil society partners. Syria is not one of those for all the reasons I just mentioned about jurisdiction. And the ICJ has no ability to collect evidence. It is no, we also often talk about there being no enforcement mechanism, no police force for these courts. But on the other side of things, there's also no investigative mechanism. And so you're not going to find a lot of state cooperation in this situation, or in many of the situations that might be called atrocity crimes. So you are really reliant on cooperation with civil society, as a lot of this evidence can be ephemeral. And in the case of Syria in particular, you have stories of individuals being detained and in their detention using tools made in the squalid facility that they were being housed with hundreds of other male inmates to write and try to document the names of their fellow imprisonees on their body so that accounting didn't get lost, that record didn't get lost. And here I really recommend, and maybe Alan's very finding links, the Syrian Justice and Accountability has excellent research. It started very small in response to the crisis, provides all sorts of services. Okay, not to escape the elephant in the room, one of the other situations that of deplorable crimes against humanity, war crimes, and potentially genocide, shocking the conscience of humanity, is of course the situation in Palestine, which again, I'm referring to the language that is used by the International Criminal Court. And here again, we have companion, I'll call them cases, before the International Criminal Court and the International Court of Justice. And we have also a lot of blowback and a lot of headwinds that some of us have to face, and I will talk about those as well, especially in my role as convener of the Washington Working Group for the ICC, and where I normally sit in DC. So with regards to the situation in Palestine, the case before the ICJ was initially brought by South Africa. And one might ask, how is South Africa implicated, in this situation across the world, where there are now 4 cases of genocide before the ICJ. And the precedent for this is Myanmar, Gambia v. Myanmar, where a small West African country, the Gambia, brought a case under the Convention of Genocide against Myanmar for the alleged crimes it was committing against the Rohingya people. And in that case, which is ongoing, at the provisional measures stage, at the stage of finding jurisdiction, rather than conclusive findings on the merits, the court concluded that it did have jurisdiction because front to the Genocide Convention, anywhere is a crime everywhere. And so because of that, we had the precedent that allowed South Africa with, I guess, I can't say optimism, but with the hope of a positive outcome that at least on jurisdictional grounds, things would move forward, to bring a genocide case against Israel. And that is the case that is currently before the International Court of Justice. Now, the Genocide Convention is the basis for jurisdiction in that case. And genocide legally, not in terms of political rhetoric, is actually quite a hard thing to prove, because you need to have a mens rea, you need to have a mental aspect that you intend to destroy in whole or part a nation or an ethnic group, a national ethnical was the terminology at the time, ethnic, I guess we'd say now, racial or religious group. And that's actually quite hard to stitch together. And there have been movements over the intervening decades since the Genocide Convention to make it a little bit, that definition more expansive. So for example, gender grounds are not included there. And again, what does it mean to destroy in whole and part? However, while Alan and I were at the Assembly of States Parties this week, and in The Hague, Amnesty International released its most recent report on the situation in Gaza, as I think that's the name of the report, which does, and we'll try to find these links, which does a remarkable job of trying to link the evidence on the ground to that fairly delimited definition. And we did also have a case recently, a request for an advisory opinion before the ICJ on the obligations of Israel with regards to the occupied Palestinian territories to the wall in Jerusalem. where there was a finding in favor of the state of Palestine, again, using the language of the opinion. And there is also in a request out for under contentious disputes, Nicaragua v. Germany, that considers Germany's how Germany may or may not be implicated by providing arms to Israel with regard to the ongoing conflict. So that is what is currently before the ICJ. And you can see that there are a number of different avenues that are being taken. With regards to the International Criminal Court and the situation in Palestine, Palestine is a state party to the ICC, to the Rome Statute. The ICC follows the UN's logic when it comes to who is or is not a state party. And it has had to say earlier in a provision and a PTC, pre-trial chamber decision, that this is not in any way a ruling on Palestinian sovereignty. That's one big myth that I often have to dispel. The case currently, excuse me, it's a preliminary examination before the ICC is not on the grounds of genocide. However, if the prosecutor, as he has requested the go ahead to look at crimes within the jurisdiction of the Rome Statute, if other crimes come up in the course of that investigation, they could be pursued. And genocide is under the jurisdiction of the ICC. But the crimes that are currently being pursued by the International Criminal Court with regards to the situation in Israel-Palestine are war crimes and crimes against humanity. And there are now arrest warrants that it took several months, but the pretrial chamber has granted for both Israeli leaders, Prime Minister Netanyahu and former Defense Minister Gallant, as well as Hamas leaders, including the leader of Hamas, who is now deceased. I think there are two other outstanding arrest warrants where the individuals are believed to be living. And here we've had well, I would say remarkable, but honestly, we were expecting this for quite a time. A huge pushback against the court and its jurisdiction, even from those who used to be friendly to the cause of international justice. I'm speaking as an American, as somebody who's looked to my Congress as welcoming the advances with regard to the situation in Ukraine and in Sudan and elsewhere and Myanmar, and also with regards to other legislatures and other individuals in orbits. So here, I'll just say a few things to try to get to some of the bugaboos that can haunt the specter of this case. There's the argument that there's no jurisdiction under Article 12 because there needs to be crimes committed in the state on the territory which the conduct in question occurred. And here this is why I've gone to pains to explain the way that the state of Palestine is recognized by the International Criminal Court, which follows from the UN, which is not exceptional in that way. And then there's one claim that is made about the principle of complementarity. The principle of complementarity is so foundational to the international system of justice. It undergirds the ICC, the ICJ, any regional court, that things start, and world federalism, we're talking as world federalists together, that a state in this case must be unwilling or unable to prosecute these crimes domestically. And here you have what I said before about state referrals. That's not necessarily a sign that a state is not on the right bent, it's not on the right trajectory. If states self-refers to the ICC, for instance, and says, at this time, we're unable to prosecute these. We're unwilling because perhaps it's been a change of government and it would look very political if we were going to prosecute these. So there are all sorts of good reasons why, complementarity is enshrined and why some states sometimes recuse that. But here, the complementarity principle, we don't have any Israeli court that is seriously looking at the crimes that are alleged to have been committed by these two individuals and potentially by others within the context of Gaza. An argument has been made that Israeli courts have convicted and imprisoned a former prime minister, a former president, and several ministers. And that's been held up as, well, this is complementarity. Look, they're willing to go after their own. But actually, the former prime minister was convicted and imprisoned for accepting bribes. Former president was convicted and imprisoned for sexual harassment and rape. And Netanyahu is also currently facing charges at home, but on corruption charges, not anything having to do with the situation in Gaza. And yes, then we get that earlier this year, the International Court of Justice concluded that the right of Palestinians in Gaza to be protected from acts of genocide was plausibly in jeopardy. And this is where the amnesty report that I mentioned has come in and has manifested that mens rea, that intent. It specifies that intent that must be manifest to justify the accusation of genocide. But that's something that is not being contemplated by the ICC at this time. The crimes being contemplated by the ICC include war crime of forced starvation, rape. I'm not going to list out the crimes by the Israeli government and by Hamas as well, of course. And I will just want to see if I missed any part of that legal argument. I'll stop there, I think, on the analysis of the current arrest warrants that are pending by the ICC in the Palestine situation. I will come back to what this talk was going to be about, which was legal alternatives to war, and how these courts and tribunals can provide recourse and can provide an alternative to conflict. Well, in these situations, we obviously see that it's too late to provide an alternative to the conflicts that have raged, the atrocities that have been inflicted on civilians, and in some cases in war crimes on individuals who might have been even enlisted against their will. But it is not too late for what comes next. And if we look at the ICC and the ICJ, not as exceptional and not as enemies of our friends and allies when it behooves us to do so, but as the normal course of action, perhaps we can have that Pacific world that was first envisioned in 1899, maybe the 1945 brought forward, the 1998 with the ICC took another step. What is absolutely essential, though, is that chorus of never again that Ben Ferencz, the last living prosecutor at Nuremberg, whose motto "Law Not War" gives our campaign its name, was his rallying cry, that not be forgotten. And even though we have seen it again and again and again, and even though we have an international criminal court because we had ad hoc tribunals for Yugoslavia and Rwanda, and the problems still kept coming, we have no alternative except justice if we are going to seek accountability for victims and survivors. And so I'll end my initial remarks there, I think. Maybe I've gone far over time, but thank you for your largesse.
Thank you, Rebecca. That was very, very informative for all of us, I'm sure. I'm afraid your internet was probably not at its peak or at the best. Some people had a problem hearing a little bit, and I think you froze a couple of times. Hopefully, that would not have had a big effect because for the most part we were able to hear you clearly. Um, so, sorry. Yes, please, everybody, put your questions into the chat for Rebecca. And I'd like to ask Dr. Dorn, as professor of defense studies, if you'd like to,
Sure.
if you have a few words to talk about, say, in terms of legal alternatives to war.
Yeah, thank you, Rebecca. That was a masterful overview of international justice today, the long arc. And yeah, it's great to get an update on all these cases. And if I have the opportunity to ask the first question, it's really about enforcement, which is so central to making international law work. After I worked at the ICC under Luis Moreno Ocampo, the prosecutor at the time, I invited him to speak to military officers, and his main purpose was to get the militaries to do arrest operations. He was indicting or putting forward the request to indict, and the court, the ICC, was indicting many people, but they just couldn't arrest them. They couldn't find them. So I was wondering if you could tell us a little bit about how the ways that you can actually bring these people to justice, and is there a role for some international forces to do arrests? For instance, I know that the UN played a role in Charles Taylor's bringing him before a court, which actually had held sittings in The Hague. I watched them in the special special court for Sierra Leone, which was held in The Hague for a while. But what do we do about enforcement? It's our biggest challenge in international law. We have all these laws and some wonderful institutional bodies, but just a really hard time bringing about justice through arrests.
Thank you so much, Walter. And yeah, it's an honor to be on the Zoom with you. And Mr. Oak is going, yes, the enforcement. And we now have repeated situations where the ICC has made it clear that there's an obligation of states parties to arrest a suspect at large. Omar al-Bashir, I wrote my law journal article on this, traveled repeatedly to many states and non-states parties. And there were numerous pretrial chamber decisions that made it crystal that this was unacceptable. And yet we have it again. We have Mr. Putin traveling to Mongolia, a state party to the Rome Statute, and he is not arrested. It is also unclear what Mongolia, what repercussions it might face, if any, for failing to comply in its duty as a member of this treaty. And so that's something that actually was really being grappled with in real time by the ICC and the ASP this week. What kind of sticks can you hold against states parties when they fail to arrest? The other side of the coin, though, is that non-states parties can also play a very important role in cooperation. The first two suspects who were surrendered to the court's justice were done so with significant aid by the United States. And when I'm talking to a very oppositional, recalcitrant US policymakers, I remind them of this fact. So therefore, there is a role for non-states parties to play. And of course, if we were to realize the goal of Democratic World Federation, and we were to have an operating, standing body that was able to rise to the task of going after arrest warrants, working with local communities, of course, including local policing forces, but also with civil society and others who know of the lay of the land, we would have a much more effectual international justice system. I guess the other thing that I'll say about that is with regards to domestic arrests and domestic enforcement of either international warrants or regional or within their own national scope. Here, it has been very helpful that we've seen the cooperation with these international bodies to build up the capacity. of domestic law enforcement agencies. And so this is what we call reverse complementarity. Same is true on the judicial side, but now we're talking about investigation and prosecution and detainment, detention, excuse me. And also we are seeing, none of these are mutually exclusive, regional and ad hoc bodies spring to life. So the hub under the auspices of Eurojust that was founded for the Ukraine situation, time of aggression, started, I think, with 6 or 7 neighbors in the United States, and then has grown and has been able to marry the learning and the expertise and the science, the forensics that each of the partners have to try to build something together. But that's only currently in the situation in Ukraine. It would be wonderful to see that kind of cooperation, I think, on a global level. And here, yes, again, Eurojust has been incredibly helpful. And yes, other regional actors as well. And I think could be seen as models, and also maybe some cautionary tales in some cases, but of where to go from a global perspective.
Any follow-up questions? No? There's a question from Anne Benton, but before I go to Anne, Dieter, do you have any questions or comments? Dieter Henrich?
No.
Am I coming?
Are you addressing that to me, Norton?
Yes, I am.
Dieter.
Dieter, yes. Do you have any questions or comments?
I just heard my name. Well, I'm fascinated. I'm on the edge of my seat listening to all of this. I thought it was just a masterful and brilliant presentation by Rebecca. Thank you. I got about 99% of it, so it is coming through to at least somebody. No, I just think that grinding forward with this whole process, all of the things that have been described, is so important as an alternative to violence and war. I mean, it seems to me like it's a very much a dualistic situation. There's the law of force and there's the force of law. And we are engaged in trying to bridge from the one to the other. And it's going to be decades, it might be generations, but the way it finally happens is in this incremental way of pursuing every little crack and opportunity to promote this agenda from all sides. And right now we're in a period, unfortunately, of institutional weakness, or the tools are very rudimentary and not very experienced, and we're not experienced in their use. People don't really think of it. And now I think in the last few years, particularly with the warrant on Putin, seems to me like I'm seeing the International Criminal Court in the news now more than ever before. In the last year, it's just much as we imagined would happen eventually when we were so involved in the negotiation of the Rome Statute. So it's great to finally see it playing a part and being recognized as part of the process. And what seems to me is that the reaction that Putin had and that Netanyahu has had, the people who are howling that the International Criminal Court would have the temerity to issue arrest warrants, it proves to me that it already is making a difference, that it matters to them that they are being singled out and being charged. And so, hooray, let's just keep going. Anyway, thank you again, Rebecca, for your wonderful presentation. I hope there's going to be a transcript, because there was so much really good insight and meat in what you said that I want to definitely have a second chance to go at it.
You were muted there. Repeat.
I just want to thank Dieter
And there will
And
be a
there
recording.
will be a transcript. There's just one question from Ann Benton, but I also see that Alan Ware's hand is raised. So I'm not sure whether you've got a question, Alan, or whether you want to add to the to what Rebecca said. I'm just going to assume. Anyway, before I pass on to Ann, would you like to say?
Thank you very much, Norbert. And so my name's Alan Ware. I'm the Program Director for the World Federalist Movement Institute for Global Policy. And along with Rebecca and a couple of others, I'm part of the core team of the Law Not War program. Just a quick announcement for those who are sitting in the room, because you may not have seen this. As Rebecca was speaking, I put links to some of the key sources, the ICJ and ICC documents that might be helpful to any of those. For those of you in the room, you may not have seen that because it's in the chat box. And so if afterwards you're saving that, you'll have some of those links to what Rebecca was talking about. I did have a comment, which was to follow up on Walter Dawn's question on enforcement. I know, Walter, you were focusing a little bit more on enforcement of the ICC, but I think your question was also about more general enforcement of the ICJ as well. Rebecca focused mostly on the International Criminal Court. I'll mention just something about the International Court of Justice, because we have done a review of these cases, looking at, at the 140 odd cases over the history of the International Court of Justice, as have some others, including Judge Wiedemann did sort of an overview of it, and the former American judge of the court also did sort of an overview. And all of us have come out with sort of a similar conclusion that the norm for decisions of the International Court of Justice is for the parties to accept and to implement them. Sometimes reluctantly, and there are some exceptions, but the norm is acceptance and implementation. This is really powerful because this includes a lot of cases where the court found in favor of the less powerful country, like in favor of New Zealand versus France over the nuclear testing, or in favor of Nicaragua versus United States, in the US support for the military support for the Contras. And there are other ones as well. Nauru versus Australia in the phosphate mining on Nauru. The court has many times found in favor of the politically or militarily less powerful country, and yet the more powerful country, as I said, sometimes reluctantly, but has indeed accepted or implemented the decision from the court. We did a little flyer of that, and I put the link to that in the chat box so you can see some of those case studies of successes of the International Court of Justice. Thank you.
By the way,
Hold on, you're muted. Sorry. Okay, go ahead.
Okay, thank you, Alan. Together with the recording and the transcript, I will be sending the chat because it's got a lot of very useful links.
Yeah,
Rebecca's got her hand raised.
the speaker wants to respond.
Go ahead, Rebecca.
Thank you. Yes, just to piggyback on Alan's comments, one of my favorite case studies from the ICJ experience is Nicaragua v. United States. And it's for a couple of reasons. Number one, the outgoing president of the court, who Alan alluded to, was working at that point for our Attorney General's office, and so Department of Justice, excuse me. And so she was on the on the defense side of that case. That case concerned the United States' funding of Contras in Nicaragua, and we were held liable for violations of international law based on our treaty commitments and based on the foundation of the UN Charter. So President Joan Donahue, as she's now known, at that point was kind of backbench supporting the United States' claim. And then I had the wonderful opportunity to study with her later when I was at the Hague Academy of International Law and hear her perspective on it today. But what happened in that case is quite interesting. So when we say that the vast majority of decisions are complied with maybe not at first, as in this case, where a powerful recalcitrant state, the United States of America, immediately says no. This court is a kangaroo court. It has no jurisdiction over us. It can't tell us what to do. But then there is a galvanization, growing momentum with civil society and also within our domestic legal framework. And I love this case particularly because it was the World Federalists movement at that point, and somebody sent me a copy of the actual trial brief that brought suit in federal court in the United States. And even though that suit itself, it went to appeal, but was not ultimately successful, it raised awareness in our country and policy changed. And not only in Nicaragua, but throughout the Central American region where the United States was engaged in regime changing. And so that is one of the ways that sometimes you have to peel back several layers of the onion to see how the ICJ works and its importance and its potency, particularly with big states like mine. And then there are others that you just get the win right out of the gate with the small states that immediately have an answer. And you get the others. Chad v. Libya is one that we like to come back to as well, where an international armed conflict can be averted or at least diverted, because there was already conflict happening, but it could have escalated so much worse if there had not been a safeguarding mechanism to go to without losing face. And so those are some of the ways in which we talk about the, not enforcement, but the other mechanisms for compliance with the ICJ.
Thanks, Rebecca.
And
Anne, thank you for your patience.
excuse me. The question actually is from Rose Dyson. You'll notice that both Rose and I are in under Ann Benton because I forwarded her the link.
Okay, all right. Okay, here's a question from Rose Dyson.
Just a minute, I've got to find her. She doesn't seem to be on the screen.
Oh, she is. She's on.
And there is Ann Benton, second one on the screen. Yeah.
Hi, Rose.
There we go.
Rose Dyson is the Vice President of the Toronto branch of the World Federalist Movement.
Okay.
Question to you is, how is it decided if a crime is to be sent to the ICC and not to the ICJ, as in the case of Netanyahu, charged not Israel?
Okay, well, not to be a boring lawyer, but going back to these jurisdictional issues again, so the ICJ, this state is the party that is liable, and under the ICC, it is an individual human person that is liable. So that's why you see Israel in the ICJ, and you see Netanyahu in the ICC. And then in terms of who decides, with the ICC, it can come up, as I said, if a state refers, it can come up if by the prosecutor's own initiative, if there's a state in question that has accepted the jurisdiction of the ICC, or it can come up by Security Council referral. And so that is how the state party jurisdiction is how the case, the arrest warrants currently for Hamas officials and senior Israeli officials are before the ICC on war crimes and crimes against humanity alleged to be committed in the situation in Palestine. Whereas in the ICJ, we have under treaty, and that's how the South Africa v. Israel genocide case has come forward, or the Canada and the Netherlands v. Syrian Arab Republic cases come forward under the Convention Against Torture, or we have exceptions of compulsory jurisdiction of the court by the states parties, or we have two states, or presumably could be more, saying that we want the ICJ to solve this matter for us. And that's why we see, excuse me, both different crimes and different, if you want to say, well, I'll say parties, I won't say defendants, but different parties between the courts. And at the same time, there is both an opportunity and a risk. There's an opportunity that we're contributing to a corpus of international law that keeps growing, and that one court, even if it has different jurisdiction, can learn from another. There's also the risk of fragmentation of international law. And then we haven't even really talked about universal jurisdiction, where you can use domestic courts that may not be related. They might be on the other side of the world from an ongoing potential atrocity crime to adjudicate that. We have Argentina looking at Myanmar now. We have Germany potentially looking into situations where it might consider war crimes, crimes against humanity, and genocide. And so there's really a test now of how well all of this fabric weaves together as a tapestry, as opposed to kind of being a quilt that it doesn't make sense and is fairly incoherent.
Thank you.
You were muted, so repeat.
Giovanni, the floor is yours.
Hello.
hmm.
Excuse me. Can you hear me?
Yes, we can.
It's fascinating. You fascinate me, Rebecca. I would like to add something more of the context, if I may. I have studies of political science basis. I'm an international business consultant. I would like to mention, underline, or to you that until 1945, the 8th of May 1945, when Germany surrendered, the European countries were fighting for centuries with battles against each other. Since the European Union has been created, there has been no war, except, of course, we have Russia and Ukraine. Are you thinking, Rebecca, to sort of move towards the creation of a world government? A world government would prevent wars and would also be useful for a distribution of wealth among all the countries of the world. So the idea to prevent war and to live in peace with justice is a world government. And today we have a strong governments. So we don't have too many governments to agree with. So I don't say it should be easy, but it should be less difficult to have hundreds of governments getting involved. Just to mention a few, we have China, we have, of course, the United States, and I may even include the Pope to create a world government. And I conclude that your contribution, Rebecca, would be of a great, great importance.
Thank you so much, Giovanni. I can respond to that. So as the executive director of the U.S. member organization of the World Federalist Movement, we are dedicated to world government. Absolutely. And so I think what we've spent a lot of this conversation talking about is one branch of that world government and what it might take and what it might look like, or what is already in place and could be enhanced. I won't say perfected, improved, which is the judicial branch. We also, however, completely support a UN Parliamentary Assembly. We also support reforms of what I would call, the executive branch, which is the UN basically as we know it. I kind of say that the UN global governance system today is a three-legged stool with 1.5 legs. There's a very strong executive with regards to the UN General Assembly, with the UN Security Council being a cabinet in a way. And then these judicial bodies that we've been discussing being that half a leg that are doing remarkable work, but are not being employed to their fullest potential. And then we're missing entirely the legislative branch and coming up with a legislative background. To me, that, that is something that must be immediately addressed. And so I believe that we have the groundwork laid with regards to international judicial institutions to start helping build that half leg of the stool to a full leg. We have wonderful proposals from friends within the World Federalist Movement, including Andreas Bummel, of course, with Democracy Without Borders for UN Parliamentary Assembly. And we have very important proposals on the table for reform of the UN, including Security Council reform, but not limited to that. And there we've just come out of this process of the Summit of the Future. I guess I shouldn't say come out because the implementation phase has now just begun. But just a couple of months ago, we concluded what had been a couple of years' journey towards what was hailed as an unprecedented moment for UN reform by Secretary General Antonio Guterres. And coming out of that, we have, I think, charter reform on a table in a way that it hasn't been for a while. We have other proposals on the table, such as the UNPA or a Global Citizens Assembly. We have the proposal that I have been talking about law not war and enhancing the jurisdiction of the ICJ, hopefully the ICC as well. And all of this, I hope, is contributing to the overall project of world government. I mean, I think that's what I'm contractually obligated to work towards. So yes, Giovanni, thank you so much for the question and the opportunity to situate this within the broader narrative.
Thank you very much, Rebecca, John, and then Dr. Rose.
Rebecca, it's John Cowan in Toronto. Can you hear me over at the corner of the screen here? You've mentioned a number of times, and the question just came up about global governance. And this is an area for sure that world federalists are involved in, as you've listed. I wanted to highlight for those who are on the call and then ask your opinion on where we go next. But just highlight that, yes, the UNPA is a thing that World Federalist Movement Canada has been pushing. The UN Emergency Peace Service, which you've alluded to the need for a UN Emergency Peace Service, you've alluded to sort of the need for a global police force. Yeah, we're somewhat pushing that. It's certainly been hatched here in Canada and gone around the world. And you've seen in the latest edition of our publication Mondial the idea of pursuing an ICJ opinion on the legality of Security Council vetoes in the presence of or in the face of atrocity crimes. And the World Federalist Movement Canada is working its way towards seeking a political action in Canada to bring that before the UN General Assembly to hopefully get some opinion about or against the inappropriate use of the veto in the Security Council. So these are all things that are building in the right direction, not instant world government. But beyond those things, what do you think a branch or even all of WFMC Canada could do in light of the current world situation, given your great knowledge in this whole area? What should we be pressing particularly hard?
Ooh, wow, that's the big question, huh? Before I struggle with that one, I just wanted to give a shout out, John. I had been in The Hague this week with my mentor, Jennifer Trahan, whose work in existing legal limits to the veto power inspired some of the wonderful advocacy that you've undertaken towards the Canadian government on the limits of the veto power. And when she screened her documentary film, WFM Canada was given a shout out. And I think you're really at the cusp here. I mean, it's moments like that, right? It's seeing the aperture, it's seeing the opportunity. And I say that there are the moments that you meet and they're the moments that you make. And sometimes it's difficult to tell the two from each other. I'm currently working on another project on an international anti-corruption court, because even with all of these judicial institutions that we've talked about, there are so many lacunae with regards to responsibility by corporate actors, so many ways in which the jurisdiction of the ICJ and the ICC fails to realize the harms that can have cascading or reverberative effects. Unfortunately, I don't think there is one grand answer. I think we need to maintain the grand vision of global world governance. And then within that, we have to multitask. At least that's what I do. So I work on veto reform issues, and I work on an international anti-corruption court, and I work on an international court of justice, UNPA, etc. And we find the spaces to do so. And we also, of course, cannot neglect, we started this out with, I think, mentioning a little bit about the climate justice opinion that's going to come out of the advisory opinion that's going to come out of the ICJ. So we cannot neglect the responsibility that we have to intervene in cases of environmental justice or indigenous justice or of nuclear disarmament. So as executive director of my organization and diverse constituency of individuals who have one uniting theme, perhaps, or maybe it's not what draws them to the organization, but they have a kernel of hope somewhere for better global governance, and then have their individual traits, their individual areas of expertise, and their individual areas of interest. Because we can't tackle global governance, I don't think, monolithically, even if we want it to be a one world system. It will be as complex as the not just humanity, but the planet is, because I think we also recognize now that the Earth has rights. Earth trusteeship is a major issue that has been coming up more and more also across my desk that we cooperate on. So you know, if I had the golden key, we I don't think I would be in my position. I think I follow in your stead and the leaders that are, many of whom are on this call, and just trying to pick up the baton and understanding also where we've been so powerful in so many areas as coalition builders. And uniting those coalitions across different thematic areas, across different interest areas, and saying that there is this common red thread of history between the different pieces that you are knitting. And it's called global governance. And you can call it Democratic World Federation, and we could talk about what that would look like. And it's not quixotic.
Thank you.
Thanks, Rebecca. I think Rose had a question, and after that, Giovanni.
Hold on just a minute.
Thank you. Well, you did ask the first one on my behalf, Norbert, and thank you for that. Very interesting and informative presentation, Rebecca. Can't begin to say that I've absorbed even a portion of it, not being a lawyer, although my late husband was very interested in helping set up the International Criminal Court and lobbied with other Canadians to get it underway. I would be very interested in hearing you say a little more about this a case before the ICJ that has been brought forward by youth on environmental issues, and you just said something about it a minute ago. But I'd be curious to know what kind of criteria is being used to establish culpability and not meeting requirements on the individual states, knowing that Canada has not exactly been exemplary in meeting its goals.
May I respond to that before we go to the other hand? And there might be other people on the line who also would like to weigh in. But the way that this advisory opinion was brought, and so it is an advisory opinion, so it's not legally binding, but an advisory opinion is very persuasive in terms of state policy going forward, and in terms of global governance going forward. And so here you actually have I think, a pretty stark contrast between just the week before the conference and parties to climate agreements, and then this judicial proceeding, which is, again, an advisory opinion process, but nonetheless a judicial process. So that the way that this came about was, as I mentioned, civil society mobilizing, asking their states to request this before the UNGA. So that's the way that an advisory opinion moves forward to the International Court of Justice. And unanimously, and Canada, I don't believe, abstained, but voted in favor, the UN General Assembly moved to request the ICJ's opinion on what the obligations are for states in respect of climate change. And there were abstentions, but there was no dissent to that request. And now, over the course of the last week and the upcoming week, you have heard testimony from states, and you will at the end, given the order of proceedings, hear from intergovernmental organizations about what they think the standards should be. I think Alan might have put in the chat the links to some of these documents, but if not, I will. And Canada has intervened. Canada intervened earlier this week. And we'll get that testimony for you to include there to see exactly what they said. And now here again, over and above, when we were talking about contentious cases before the ICJ and there not being an enforcement mechanism, I said that this is not legally binding, but this will have huge, I think, reverberation about what it means within a legal context to violate the environment. And over the course of the proceedings, there have also been some unprecedented, maybe they seem small, but procedural aspects that have come up. So, for example, the judges met with a group of senior scientists and another group of esteemed environmental lawyers, and we're factoring all of that in. And then there was kind of the question of whether or not the court was perhaps acting ultra vires, so beyond its powers, because it seemed to maybe be taking scientific and academic opinions before considering the arguments of states, which it's meant to consider. And so this is actually also testing what the ICJ is meant to do and how it does it, which is quite interesting for a geek like me, and quite important for understanding what the ICJ's capacity is going forward. But so yes, I'm not sure if that completely answered your question, but we'll get the Canadian testimony to put in the chat, hopefully, or just give you the link to where all the testimony can be found.
Thank you.
A repeat.
Thanks, Rebecca, and over to Giovanni.
Unmute Giovanni, please.
Giovanni? Giovanni, have you unmute yourself?
Well, we don't seem to have Giovanni unmuted. Is there anybody else with questions?
Okay, anybody else with a question? All right, so I think I invite Walter down to thank Rebecca and wrap the section up. And once we're done, if there's anybody who's got any questions regarding World Federalism or the World Federalist Movement, those who are not part of us, we'll stay on for a few minutes to answer those questions. Walter, over to you.
Right. Well, I'm delighted to thank Rebecca. We've already heard the adjectives used of wonderful, masterful presentation, including in our answers to our questions. It's really special to have someone with both expertise and ideals. There's lots of people in the world who have the expertise, and there's lots of people with the ideals, but to bring them together, as Rebecca did today, was a great combination and follows in the tradition of Bill Pace on this issue. And good luck on all your travels to the capitals and trying to influence states. It's so important because the international courts now have a greater prominence. The prosecutors are putting forward in the motions to indict, and it's going all the way to heads of state. And to imagine that Vladimir Putin and Benjamin Netanyahu are indicted, that's so exceptional in the history and the long arc of the law. And I think it also means that the courts will be challenged, and challenged in major ways, including by attacks, not just verbal, but cyber attacks, planting of false evidence, attacks on personalities, people, including the prosecutor of the ICC. And so they really need support. They need moral support. They need funding support. They need civil society support. And so this is great to hear that, you know, that we are still active and we are pushing the cause, and the people who are the internationalists are still at work, even as the world seems to get more conflicts and more violence. So I leave this meeting very much encouraged that there is progress being made, and that despite all of that violence and the shift in the world today towards, as Dieter would put it, or had put it, the rule of the law of the jungle, or the law of force, that the force of law is still in competition, and that we can hope that in this competition we can actually see the rule of law prevail. And it's really encouraging to see that, because it doesn't get many headlines, that behind the scenes there is all this progress and the courts are working away, and this great institutional framework and establishment that we have seen in the last quarter century is moving forward. And through those travails, we'll actually see that those mechanisms can be enforced and reinforced. And hopefully at some point we'll be able to get the kind of national capability to help the court to actually arrest people whom the court has indicted, possibly at the invitation of governments who need help doing the arrests. But in any case, Rebecca, thanks so much for being such a wonderful guide on this subject, for helping us to deal with the complexities, and for all of your wonderful work. We really wish you all the best as you go forth, and we hope that there are many more of you to help push the world forward, so we can actually have that rule of law and a movement towards global governance that actually is a strong governance, and eventually in our World Federalist dream, a world government that is truly fair and has the checks and balances needed in order to have that major responsibility for federation of these disparate states. So thank you again, Rebecca, and all the best to you in your travels and your work.
Thank you.